truth and nothing but the truth?
I swear.
Thank you, ma'am. You may put your hand down. Ms. Mojica,
Yes, Judge.
in this matter, we're going to go through a proceeding wherein you intend to submit a plea. Before we do that, I'm going to share with you at least 5 important rights and constitutional protections that you apparently will be giving up. That will be done verbally, and the official court reporter will be making a record. When we're through with that, we're going to go through the paperwork, and the paperwork will repeat sometimes 2 or 3 times the different rights and protections that you have that you're giving up. The first one is the right to remain silent. That means that you do not have to make a statement of any kind. You don't have to answer questions, and you don't have to submit paperwork with your signature, especially papers that admit or confess to wrongdoing. You understand you have that right?
Yes, Judge.
You have the right to a jury trial. That means that you and your attorney and the state's attorneys would select 6 people, at least 6 people from a pool, a random pool of jurors. And those 6 people would hear the evidence, see and hear everything by way of testimony or materials, and then decide whether you're guilty or not. That's the right to a jury trial. You understand you have that right?
Yes, Judge.
You have the right to face your accusers, or that is to confront the witnesses. That means you and your attorney can ask questions, cross-examine, or challenge any witness who would testify. You understand you have that right?
Yes, Judge.
There's also a right to appeal. That right means that you yourself or your attorney or the 2 of you together can demand that a higher court review the official record, the evidence, and the results of this hearing for whatever challenge you wanted to make. That's called the right of appeal. You have to follow the right time limits and the paperwork that's required. That's the right to appeal. You understand you have that right?
Yes, Judge.
Also, you and the state individually, that means you and the prosecutors have the right to demand that this hearing be done in open public courtroom. Because of the COVID pandemic, we're not doing that right now. What we're doing is video conferencing by computer, as you know. Now, you need to know that this is being live streamed on YouTube, but it is still not what the Constitution and the statutes require. That is the open public courtroom. The state has that same right. Do you understand you have that right?
Yes, Judge.
Those rights are given up by you if you proceed and insist on this plea, this agreement. You understand you're giving those rights up?
Yes, Judge.
All right. Now I'm going to show you some papers with the help of Ms. Garcia. You'll notice at the top, all of the papers, with one exception, will have this, what I call identifying information. It's case number 649991, the state of Texas versus Emily Ann Mojica in County Court of Law number 5, Bexar County, Texas. This one, and by the way, that will be repeated on the papers. Then the next thing is the title of the particular document. Right now at the top, you'll see that it says states consent to video conference. Since they have the right to demand this be done in a public courtroom, they also have to agree to do it by video conference, just like you will. So you notice that Ms. Caitlin C. Morgan, the Assistant District Attorney, has signed the agreement to go by video conference. You understand that? Did you see all this?
Yes, sir.
Now, all these papers, did you and your attorney review them carefully?
We did, yes, Your Honor.
Do you have any questions about the papers that we're going to be showing you?
I do not at the moment.
All right. If you do, please say so.
Yes, sir.
The next document that you're seeing right now repeats the identifying information because this is a different type of document. This one is titled Discovery Acknowledgement. The titles of these documents are in bold print, all capitals. This one talks about a law called Article 39.14 of the Code of Criminal Procedure. This particular law requires the state of Texas pretty well to give you all the information, acknowledge it, and make it available to you. All the information, evidence, videos, receipts, books, whatever is involved in this case that is relevant and that would be important for you to decide to make an informed and intelligent decision. This particular document is signed by the assistant district attorney and your attorney saying, hey, this law has been obeyed. Now I'm showing you a document where you yourself have said, yes, I agree to video conference. Did you sign this?
Yes, sir.
And your attorney?
Yes.
All right. All these documents will be made of record. Now, I'm showing you now a very important one. This one is, again, the identifying information, and the title of this document is Defendant's Waiver of Constitutional Rights and Court's Admonitions. Now, in this particular case, you'll notice that it says that you were charged with DWI originally charged, when you were arrested, you were charged with DWI with a blood alcohol content of 0.15 or higher. That means that this was what we would refer to as extreme intoxication. All right? Now, this document now says, the third sentence up there says that you're going to plead nolo contendere, there is no contest, to the charge of DWI first. So that means your attorney has gotten in agreement with the state to reduce it. The original charge is a Class A misdemeanor. If you look at the rest of this document, by the way, is divided into 15 separate divisions or separations. Each one has a specific number. The very first one, do you see it right in front of you there on the screen?
Yes, sir.
The very first one talks about the range of punishment. Now, I want you to look at that. You see where it says DWI with blood alcohol BAC of 0.15 or higher? That's the second square. What does it say about the punishment for that? Fine, $0 to $4,000, in jail 0 days to 1 year. Now, your attorney got this to DWI first, so it was reduced to a range of punishment of fine from $0 to $2,000, that's half. And then it has jail 72 hours to 180 days in jail. You understand that's the range of punishment for your particular offense?
Yes, Your Honor.
All right. Now, the rest of these paragraphs, or divisions, did you carefully read them with your attorney?
I did, yes.
Do you have any questions?
I do not.
Where were you born, ma'am?
I was born here in San Antonio, sir.
All right. The records will reflect that you are a U.S. citizen.
Yes, sorry.
And you reviewed this document, you signed it, and so did your attorney. Is that correct?
I did, yes.
All right. The document now that you're seeing is, again, with the identifying information. This one is my certification to you, the trial court certification of defendant's right of appeal. The fifth little box, with each box, there's a stack of boxes vertically stacked, and each one says something different about a different right of appeal or how it affects you. The fifth box, which is at the top right now being shown to you, in there I declare that this is a plea bargain case, a deal, and the defendant has no right of appeal. Did you understand that?
Yes, Your Honor.
All right. Ms. Espinosa,
Yes, Your Honor.
did you review this document carefully with your client, the one that I just finished looking at?
Yes, Your Honor.
And are you satisfied that she understood what she was signing?
Yes, Your Honor, I am.
All right. Now, the document you're being shown now, Ms. Mojica, is titled Application for Deferred Adjudication. couple of things that I want to make sure you understand, ma'am.
Okay.
Deferred adjudication is a special kind of community supervision, a probation. In here, the really critical and important part is that I will make a recitation concerning whether you're convicted or not. That'll be part of the record, and it is agreed to. And also, if you live up to 100% of the conditions of supervision, you will not be convicted of this charge. The DWI first, there will not be a conviction. If you fail or refuse to live up to all the conditions, 100%, then the state can ask me to bring you in after notice and have a hearing. At that point, if the evidence is sufficient, then I can enter a final and forever conviction. Is that understood?
Yes, Your Honor.
If that happens, then you're looking at the full range of punishment. Fine, $0 to $2,000. Jail, 72 hours to 180 days. I need you to understand that. Now,
Yes, sir.
I mentioned that you have to live up to 100% of the conditions. Those conditions will be read to you. You will sign them. You will have a copy in your hands. Is that clear?
Yes.
Now, for the record, did you know and understand what you were telling me when you signed this document, making that application?
Yes, Your Honor.
And Ms. Espinosa, did you explain to her what what her commitment is as far as what she signed in applying for deferred adjudication?
Yes, Your Honor, I did.
All right, now here's the personal data sheet. That's the only one that doesn't have identifying information. And I guess you can understand it because the whole thing is identifying information. Has your name, address, where, you're not working, ma'am?
No, sir. I'm a nursing student.
Okay, you are a student, okay?
Yes, sir.
When are you gonna finish?
I actually graduate in 3 weeks.
Great, congratulations
sir.
to you.
Thank
All
you
right.
very much.
What kind of income do you think you'll be making?
I play music. I play mariachi music here in town. So that's more of my income right now.
I know, but you said you were gonna graduate from nursing school?
I am, yes, sir. So after that, I'll actually be going into another program to get my bachelor's. So I'll be a full-time
Okay.
student and working music. Yes, sir.
So you're gonna get a BSN RN?
BSN, yes, sir.
Very good. Well, congratulations. I'm happy for you.
Thank you very much.
But don't mess it all up by getting any more DWIs, you hear?
Of course not. Yes, sir. I've learned my lesson.
Good. We're here to help you, but we're also here to keep you in line.
Right. Thank you.
All right. You are single, no dependents,
No, sir.
and you got a nice little vehicle. All right. Now we're going to have, it'll take a moment. We're going to reload the computer here, and we're going to do what's called a plea agreement, and we'll finish the plea, okay?
Okay. Thank you.
All right. The identifying information here does not have the County Court 5, but it's not required in this case. The first two boxes you're seeing there on the document called plea agreement, they will be marked. The first one talks about, guess what? Your right to remain silent. It repeats it because it's a critical right. Then the second box identifies you as a U.S. citizen. Now, Ms. Espinosa and Ms. Mojica, the next section there says defendant's acknowledgements. Did both of you know and understand what you're saying there, Ms. Mojica, by checking off those boxes?
Yes, Your Honor.
All right. Now, to the charge, now officially, you were originally charged with DWI extreme intoxication. State, you have a motion.
Yes, Your Honor. The state moves to waive and abandon the extreme intoxication enhancement and proceed on a DWI first.
All right. Defense, any objection?
No, Your Honor.
And I will mark that little box there says motion granted. I do grant that motion. So Ms. Mojica, officially, you're no longer charged with extreme intoxication. The charge now is DWI first. And as you know, you're seeking deferred adjudication.
Yes, Your Honor.
Officially at this moment, how do you plead to the charge of DWI first?
No contest, Your Honor.
All right. A no contest plea in this court is considered a guilty plea. Do you understand that?
Yes, Your Honor.
That plea is sufficient for me to find you guilty. Is that understood?
Yes, Your Honor.
All right. Now, I order you to appear in the offices of County Court at Law Number 5 within 7 days. You're to have your thumbprint placed on the documents as required by the law under Code of Criminal Procedure 38.33. You don't need to know the particular law. Just come in and give us your thumbprint.
Okay.
I find there is sufficient evidence to find you guilty, including your own plea of nolo contendere. But I do not find you guilty. I am granting you the deferred adjudication for 12 months. You will not apply for early termination of community supervision. I am fining you $500, and of that $500, I will probate $250. That means that if you live up to all the conditions, which you must, then $250 of the $500 will be forgiven. You are to perform 48 hours of community service restitution. Is that clear?
Yes, sir.
All right. In addition, you will participate in, enroll, and complete the DWI education program, the DWI Victim Impact Panel, a TAP evaluation, and follow the recommendations. For 6 months, you're going to have ignition interlock installed on that nice little vehicle that you have. During the entire time of the deferred adjudication, you're not to have not one drop of alcohol. And for the 6 months that you have ignition interlock in there, you're not to drive any vehicle other than the one that you have that has the ignition interlock. Is that understood?
Yes, Your Honor.
Your supervisory fee will be $34 a month. Ms. Mojica, do you have any questions?
I do not, Your Honor.
Ms. Morgan?
Nothing from the state, Your Honor.
Ms. Espinosa?
No, Your Honor. Other than to let you know, she was taking an exam this morning. That's why she was running late. So
No problem. Okay. I'm glad to hear
Thank
that.
you.
There was a very
Thank you.
legitimate reason for it. Ordinarily,
yes.
I am a little bit incensed when people show up late, particularly lawyers. All right. Then